A Senate Appropriations Committee hearing turned into a sharp debate over the rule of law, the authority of federal courts, and the role of executive agencies in enforcing immigration policy. Senator Chris Murphy pressed DHS leadership on whether court orders would always be followed, while the administration defended its actions and argued that some judicial decisions have become increasingly politicized. Watch the exchange first, then we'll break down the constitutional issues at stake and why this disagreement goes far beyond a single immigration case.
Mr. Secretary, this is from a federal court decision regarding ICE's activities in Minnesota. ICE is not a law unto itself. ICE has violated nearly 100 court orders. This list should give pause to anyone, no matter his or her political beliefs, who cares about the rule of law. ICE has likely violated more court orders in January 2026 than some federal agencies have violated in their entire existence. That's not a Democratic-appointed judge. That is a Republican-appointed judge describing the scale of illegality. I understand your MO and others in the administration's MO is to attack us personally or to claim that we're inciting violence when we point out the widespread illegality. But this is a Republican-appointed judge who is saying the exact same thing that I am saying. This is a really important discussion for us to have, because this is, whether you want to believe it or not, at the root of our disagreement, is that it is very hard for us to figure out how to fund an agency that is violating the law. Again, that's not me saying it. That's a Republican-appointed federal judge. Now, this widespread violation of court orders admittedly largely happened before you got on the job. And as a senator, you always struck me as somebody who cared about the rule of law. And so maybe the easiest question is this. When DHS gets a court order telling them that something they are doing is either illegal and unconstitutional, prior to you taking office, the approach was to ignore that court order. That's what this judge is saying. 94 times you got a court order, you didn't implement it. Now that you are on the job, can you commit to us that if a court judges something ICE is doing, something DHS is doing as illegal or unconstitutional, tells you to stop, that you will comply with the court order?
Ranking Member Murphy, I will tell you that we will never break the Constitution, and we're not going to break the law, but we're going to enforce our nation's laws. And we're going to enforce the laws that you guys passed and that we implement. We will never go outside that, and if we do, we'll hold each other accountable for that.
But that doesn't sound like the same thing as committing that you will obey a court order. Obviously, the entire structure of the federal government gives the power to the federal courts to divine whether you are obeying the law or not. I mean, I think it's an easy thing to say. Will you or will you not implement court orders?
If we didn't think courts were politicized, then I would probably be able to answer that. But we see courts over and over again that use their bench for their political opinion, not just the rule of law. And we can see that because we see how many times they're overturned.
Choose which court orders you obey based upon whether you believe that
what I said
to be
political. Don't put words in my mouth.
That's what are you saying then?
What I'm saying is we'll enforce the law and we're never going to break the Constitution.
You just said that you will not follow every court order because you
Chris, Senator, don't start putting words in my mouth. That's not what I said. I said I will never break the Constitution. We're going to enforce the law.
Will you implement court orders when they tell you to stop an activity?
You're making an assumption on court orders I haven't seen.
Will you or will you not?
I am going to enforce the law, and I'll never break the Constitution.
I think, listen, if you're a Republican or a Democrat on this committee, you should be really freaked out.
We should be really concerned about the rulings that come out of the courts and how often they get overturned.
It falls apart if you are telling me that
they fall apart when you have a judge that makes a political opinion from a bench and they're outside the law too. Not all judges are above the law, but sometimes they think they are. That's why we see lower courts get overturned by higher courts constantly.
Let me ask you about what's happening in Delaney Hall. You said that detainees are protesting there because they want their, quote, ethnic food. I have 3 official letters that were sent to the administration from about 300 detainees there. It won't shock you that there's no mention of ethnic food in these letters. These letters allege that there has been spoiled food, delayed medical treatment, sewage backups, undue pressure to sign deportation paperwork. Madam Chair, if I could submit these letters for the record.
Without objection.
Nowhere in these letters is a demand for ethnic food. They describe pretty horrific conditions. This administration has defunded the ombudsman, the independent office that used to exist inside DHS that would do an independent investigation of claims like this. Can you just tell us, if you're taking these claims seriously, these allegations seriously, and looking at them, or whether you've prejudged this to be, as you stated, about a demand for ethnic food? These seem pretty serious, and it seems like you would want to investigate.
So since the history of that facility being open, not one single health violation has been written. In fact, just recently, the state of New Jersey's health inspectors went in. They didn't find one single violation. But if you compare it to what the state prison system is, state prison system, they have 3 prisons that are in deplorable conditions. Quote, that's what the health inspector said. Delayed health care is average of 32% delayed within 48 hours. We have more health. We have 2 times. No, yes.
Are you doing an investigation on these allegations?
Ranking member, this is why I had this information, is because I went through and looked at it and looked at what we have. 0 health inspections.
Not everyone is a health inspection allegation.
You made some pretty damning claims saying that it's deplorable conditions.
Or not?
I said we looked into it. Health inspectors were just there.
Time has expired.
And we had 0 violations. 0 violations.
What made this hearing significant was that it exposed one of the deepest disagreements currently shaping American politics: who ultimately decides whether the government is acting within the law. On the surface, the exchange appeared to be about immigration enforcement and court orders. But underneath that discussion was a much larger debate about constitutional authority, separation of powers, judicial oversight, and public trust in government institutions. Senator Chris Murphy began by citing a federal court decision criticizing the conduct of immigration authorities. Importantly, Murphy emphasized that the criticism did not come from a Democratic-appointed judge but from a Republican-appointed judge. That distinction was not accidental. Murphy was attempting to make the argument that concerns about compliance with court orders are not merely partisan objections. His point was that judges appointed by different administrations have raised similar concerns about government conduct. Murphy's central argument was straightforward. In the American system of government, courts exist to determine whether executive branch actions comply with the Constitution and federal law. If a court determines that a government action is unlawful and orders that action stopped, then the executive branch is expected to comply. That principle forms one of the foundations of constitutional government. The judiciary interprets the law. The executive enforces the law. Congress writes the law. Each branch has separate responsibilities, but the system depends on each branch respecting the constitutional role of the others. Murphy's concern appeared to be that repeated disputes between immigration authorities and federal courts are creating uncertainty about whether executive agencies fully accept judicial authority. This is why he repeatedly asked what seemed like a simple question: would the agency comply with court orders? Notice that Murphy asked essentially the same question several different ways. He wasn't asking about a specific case. He wasn't asking about a hypothetical policy. He was trying to obtain a broad commitment regarding compliance with judicial rulings. The Secretary's response was equally revealing. Rather than directly answering yes or no, he repeatedly returned to a different theme. He emphasized enforcing the law and upholding the Constitution. At first glance, those statements might sound similar to what Murphy was asking. But there is an important distinction. Murphy was asking about obedience to court orders. The Secretary was emphasizing obedience to the Constitution. Those are related concepts, but they are not exactly the same thing. That difference became the central conflict of the hearing. Murphy viewed judicial rulings as the mechanism through which constitutional disputes are resolved. The Secretary appeared focused on situations where he believes courts may be acting politically or exceeding their proper role. This disagreement reflects a broader debate that has intensified in recent years. Many elected officials from both parties have criticized judicial decisions they disagree with. Some argue that courts have become too willing to involve themselves in policy disputes. Others argue that courts are performing exactly the oversight function the Constitution intended. Neither position is entirely new. Throughout American history, presidents, governors, lawmakers, and political movements have often clashed with courts. What makes the current moment different is the frequency and intensity of those disputes. One of the most striking moments occurred when the Secretary stated that courts can become politicized. This is a view held by many Americans across the political spectrum. Critics of the judiciary often argue that some judges are influenced by ideology rather than legal reasoning. Defenders of the judiciary argue that accusations of political bias can undermine confidence in the rule of law. Both perspectives are represented in contemporary political debates. The hearing illustrated that tension in real time. Murphy seemed concerned that questioning judicial authority could create a dangerous precedent. His argument was essentially that government agencies cannot decide for themselves which court orders deserve compliance. The Secretary appeared concerned that some courts are issuing decisions that reflect political preferences rather than legal principles. Those are fundamentally different concerns. One is worried about executive power. The other is worried about judicial power. The Constitution was designed to balance both. The discussion then shifted toward conditions at an immigration detention facility. This portion of the hearing was significant because it revealed another common feature of congressional oversight: competing factual narratives. Murphy introduced letters from detainees describing alleged problems including food quality, medical treatment concerns, sewage issues, and pressure related to immigration proceedings. His purpose was to show that serious allegations existed and deserved investigation. The Secretary responded by citing inspections and reviews that reportedly found no violations. Rather than accepting the allegations at face value, he argued that official inspections had not confirmed the claims being made. This created a classic oversight dispute. One side presented complaints and testimony from affected individuals. The other side presented findings from inspections and administrative reviews. Congressional hearings frequently involve these competing sources of information. Lawmakers often elevate concerns raised by constituents, advocacy groups, whistleblowers, or affected individuals. Agency officials often respond with data, reports, audits, inspections, or internal reviews. The challenge for the public is determining how to evaluate conflicting claims. Another important aspect of the hearing involved the discussion of independent oversight. Murphy referenced an ombudsman and inspector general functions that could independently investigate allegations regarding detention conditions. This may have seemed like a minor procedural issue, but it touches on a major principle of government accountability. Independent oversight mechanisms exist because neither lawmakers nor agencies are always viewed as neutral by the public. Inspectors general, auditors, and independent investigators are intended to provide a level of credibility that political actors sometimes cannot. When disputes arise regarding detention conditions, law enforcement conduct, or administrative practices, independent reviews often become the most trusted source of information. The broader significance of the hearing extends beyond immigration policy. At its core, this was a debate about institutional trust. Can the public trust courts? Can the public trust executive agencies? Can the public trust inspections and investigations? Can the public trust political leaders when they describe what is happening? These questions increasingly shape modern governance. The exchange also demonstrated how difficult it has become to separate policy disagreements from institutional disagreements. In previous eras, lawmakers might disagree about immigration levels, border security, or detention policies while still largely agreeing on the authority of courts and oversight mechanisms. Today, debates often involve the institutions themselves. People are not only arguing about policy outcomes. They are arguing about who should have the power to decide those outcomes. That is why Murphy kept returning to the issue of court orders. For him, the question was not merely administrative. It was constitutional. Likewise, the Secretary's responses reflected concerns that some institutions may themselves be acting improperly. For him, the issue appeared to involve ensuring that executive agencies remain focused on enforcing laws enacted by Congress rather than responding to what he views as politically motivated rulings. By the end of the hearing, neither side had fully answered the other's concerns. Murphy never received the simple yes or no commitment he was seeking. The Secretary never accepted Murphy's characterization of the situation. Yet that unresolved tension is precisely what made the exchange important. The hearing was not merely about immigration enforcement. It was about how power is distributed within the federal government. It was about the relationship between courts and executive agencies. It was about accountability, oversight, and constitutional authority. Most importantly, it was a reminder that many of today's political battles are no longer simply about policy. They are about the institutions responsible for interpreting, enforcing, and overseeing the law itself. And when disagreements reach that level, they tend to become some of the most consequential debates taking place in Washington.